We're seeing roadblocks being set in front of the plaintiffs for the James v. Mederos lawsuit. That's our challenge on AB 28 and the 11% tax. We also want to tackle some questions and comments from the community, so let's talk about it. Hey everybody, welcome back to the channel today. While we continue to wait and watch for litigation to happen at the Supreme Court level and for some of these state level lawsuits that we have brought, I thought it would be a good idea to circle back to James v. Mederos. That is the 11% tax challenge that we brought at the latter end of last year. Just because I've been getting some questions about it, obviously it's hurting people with having to pay 11% more. That tax continues to be passed down. It's affecting the FFLs, the manufacturers, and the consumers. So I thought it would be a good idea to touch on it, since the last time we touched on it was when we filed the lawsuit. To walk us through that today, I have brought a partner from Michelle and Associates. That is Josh Dale, to walk us through that. Josh, thanks for being on with us today.
My pleasure. Thanks for having me, Kevin. And I'm hopeful I can answer questions for some folks, because I know this is a very hot topic.
Yeah, definitely is. And before we get into that, guys, as always, be sure to like, share, and subscribe to these videos. It really helps with the algorithms to get this message out there as far and wide as possible. Of course, here we are hearing from the attorneys who brought the lawsuit, so hopefully we can answer those questions as well as we possibly can as we move forward with this litigation. So, Josh, if we can let's not necessarily jump into the questions. Let's give a background for those who maybe haven't been following along. Obviously, we followed Assembly Bill 28 very closely. We advocated against it very heavily. It's not just a bill that popped up last year or the year prior either. This is what our legislative director, Rick Travis, called a zombie bill, because the legislature had been proposing excise taxes on the firearms community for 6, 7, 8, 9 years in a row. I guess the only difference is that all of those past years we were able to defeat it in the legislature. AB 28, we were not. It got signed by Newsom and imposed, so that 11% tax started getting charged. Insert the lawsuit then, since the legislation was signed. Can you walk us through the challenges in James v. Mederos, as well as the path that it's taken in litigation so far?
Yeah, absolutely. And you touched upon a key point, which is, although this excise tax has sort of sat out there for a while, this was very much a response to Bruen and an attempt to test the bounds of Bruen and Bruen's mandate with regard to the right to carry and the bounds of the Second Amendment. And so it was very, once they set their mind to getting this passed, it was very well crafted to see sort of where they could get to the line of the Second Amendment without crossing over it, and in the form of a tax challenge, which or a tax which has its own unique issues when folks try to challenge them, and I'll talk a little bit about that. But to the procedural background, there were actually two lawsuits filed. One filed by CRPA and its partners, challenging the tax, and another one filed by an attorney down in San Diego on behalf of an individual who was challenging his having to pay the effects of the tax in terms of increased costs of purchasing firearms. That case was called Altbaum v. California Department of Tax and Fee Administration, and that case got dismissed right off the bat. It got dismissed in the pleading stage on a demurrer by the CDTFA. In the meantime, we also filed our lawsuit. Our lawsuit did include some individuals, but the primary component of our lawsuit was it included the dealers that actually have to pay the tax, that are actually responsible for remitting it quarterly to either the CDTFA or, in some rare instances, the FTB. And when we filed it, we initially waited to move forward on it because we needed those dealers to pay the tax. And I'll talk about this in a little bit. One of the unique things about challenges, whether they're constitutional challenges or not, in the arena of taxes, is that in most instances you have to pay the tax before you have standing to challenge the tax law. And it's a very weird area of constitutional and what I'll call the right of the sovereign where there are additional hoops and additional procedural issues you have to take into account. And that's part of the reason why we had to wait until our dealer plaintiffs paid their first quarter taxes to actually bring them in as plaintiffs in an amended version of our complaint. And we'll talk about some of the additional challenges now that we're facing on that. But so where we're at right now is the state has filed a demurrer to this amended complaint, and they're raising an issue called the administrative exhaustion of remedies doctrine that I'll talk about. And so what we are likely doing at this point, and we're doing this in conjunction with our litigation partner, which is Cooper and Kirk. They're the nationally renowned firm out of Washington, D.C. They've partnered up and in fact have taken the lead on this case. But we're probably going to dismiss, at least for the moment, to blunt the exhaustion of administrative remedies defense that the state has unfortunately identified that it wants to bring. And I'll talk more about that in a little bit. But that's where we're at.
So you were mentioning procedure. This law was challenged in a state court, correct? And kind of what we're used to is challenging in federal court. Can you speak at all to the challenge being brought to the state superior court as opposed to a federal court, why we had to do that, and also kind of the state of the superior court system itself?
Yeah, and again, this is one of these weird things involving tax challenges. As a general rule, the federal government does not like to be in the business of deciding whether state taxes are appropriate. There are some exceptions to that, but in general, federal courts are constrained by two laws passed by Congress. One is called the Anti-Injunction Act, which generally says that federal courts should not be final courts of appeal with regard to state court actions. And then there more specifically is something called the Anti-Tax Injunction Act, which specifically says that federal courts should not be final courts for dealing with challenges to assessment of state taxes. And so this is one area that is very different from other challenges, such as challenges to searches and seizures or challenges to ownership of firearms, where you can go directly to federal court and say, hey, my civil rights are being violated. Congress has very clearly indicated for the most part, you have to keep these challenges out of federal court. They're going to get dismissed.
So basically, I mean, what you're saying is we didn't have a choice. Is that what I'm understanding here?
We could have filed in federal court, but all the lawyers looked at the cases and we considered it, and we thought the likelihood that we wouldn't get dismissed out of a federal court if we just brought a pure Second Amendment challenge was extremely low, and that our likelihood of prevailing was much higher if we brought state tax challenges along with a Second Amendment challenge in state court. And so that's ultimately why we did not go into federal court. The history of people trying to bring challenges to state taxes in federal courts is woefully poor. And again, because of these, not only this congressional law, but it's a British common law doctrine that goes back centuries with regard to the right of the sovereign. In the case of Britain, it would have been the king, but here it would be a state or the federal government to decide how it's going to impose taxes and collect those taxes from its subject citizens.
So you were also mentioning that we kind of came to a point in the process where things needed to be exhausted. Can you go into that a little bit? The last time I checked, we were looking at putting our briefs in. We were waiting for the state's briefs to come in. What's the roadblock now that we're facing?
Well, so we've always understood that we're facing a balance of trying to get relief for folks from having to continue to pay this excise tax versus all of these procedural roadblocks that exist with a tax challenge. And so the strategy early on was, let's see if the state actually raises the exhaustion of administrative remedies issue, because if they don't, we may be able to get to the substantive issue of the validity of the tax sooner. Unfortunately, they did. And the problem with going through the exhaustion of the administrative remedy, which here is an appeal to the CDTFA over payment of this tax, is that it takes time. It's an administrative process. It's just like appealing a license suspension to the DMV. You have to go through a process of submitting your appeal. And here, the issue is sort of doubly infuriating because not only do you have to appeal it to the CDTFA, but most certainly you're going to lose because we're not saying to the CDTFA, no, you calculated the excise tax of one of our dealer plaintiffs incorrectly. We're saying you shouldn't be assessing this tax, you shouldn't be collecting this at all because we think it's illegal. We think it violates the Second Amendment. We think it violates a couple other doctrines. And so therefore, you should give us all our money back. And the CDTFA is naturally going to say, no, we were authorized by state statute by AB 28 to collect this, and so we're going to collect it. So we were hoping to avoid that process. And in doing so, we would have cut a great amount of time out of this challenge. The problem was, no, the state's lawyers were smart enough to go, no, we're going to assert this exhaustion of administrative remedies defense. And so now we have to go back and actually go through that process. The reason we have to go through that process is that uniformly, when it comes to tax challenges, the failure to actually go through the process of paying the tax and go through the remedies to appeal the payment of that tax is fatal to cases. And it is a weird area of law. I've seen it in other contexts. And I'll give you so the viewers understand. I'll give you an example. You get a bill from the IRS and it says, oh, by the way, we think you earned an extra $3 million and you owe us $500,000 in unpaid tax on that. And you go, wait a second. I didn't earn an extra $3 million and I certainly don't have $500,000 to pay you. I want to challenge this. You cannot challenge that until you pay the $500,000. And it's one of the rare areas of the law where you have to actually pay the penalty or pay the damages before you can actually get your day in court. And folks have brought due process challenges to this sort of scheme of how you deal with tax issues and have lost spectacularly. And that was part of the reason behind why we were waiting to bring the dealers in who actually paid the taxes so that we could then move forward. And again, crossing our fingers that this exhaustion of administrative remedies defense wouldn't be raised. And unfortunately, it has.
So, I mean, so the terrain is kind of laid out. It sounds like you got a lot of cases to reference for challenges like this, and we're playing it safe. We want to make sure that we can get to the substantive arguments that this tax is unconstitutional, essentially. And if we got to jump through hoops to get there, then we're going to jump through those hoops. Unfortunately, those hoops take time. Am I getting that right?
Yes, you are getting that right, because here's the thing. For us who are firearms enthusiasts or who support the Second Amendment, the idea of an extra 11% payment in order to obtain the tools to exercise that right seems unfair, unreasonable, abhorrent. But in the scheme of taxation, it's not outside the realm of defensibility. And so we can't just go out there and say, this violates the Second Amendment, repeal it immediately. We have to make more nuanced arguments. We have to make arguments with regard to the legislative intent behind AB 28 and their claims that they're going to use this 11% to offset the effects of us engaging in our Second Amendment rights. And so this isn't, I'll give you an example. This isn't as clear-cut as something like a poll tax challenge, where very clearly a poll tax is passed to prevent African Americans from voting, and that's in the legislative history. That's in the statements of people on the floor of the legislature, and so you can say, look, this is specifically designed to prevent the exercise of the right. Here with AB 28, we know it's designed to discourage it, but it's not inherent in the law. What the law pretends that it's designed to ameliorate the effects of gun violence. And we know from studies and stuff that that's not what this money's going to go towards, and it's not going to help in those situations. And it's really designed to make it more difficult for people to obtain firearms, to discourage it. But we can't just go, this is our position, and we believe that 11% is too much, and so strike down the law. We have to go through this entire process of making these more detailed challenges to effect, intent, and that's why um, we also have to go through the dance of now exhausting administrative remedies.
And it doesn't seem far-fetched to believe. I mean, I'm sure the state knows where we're coming from, and they know essentially what we want to do. They know that exhausting that, isn't going to be something that allows us to get to those substantive arguments unless we do it. So it becomes a delay, like a delay tactic. It wouldn't seem far-fetched for me to believe that. And speaking about that, maybe we can start speaking to some of these comments, concerns, and questions that I've been getting. I'm sure you've been getting a lot of them as well. One of them having to do with delaying the lawsuit. When we were originally talking about Assembly Bill 28, there were plenty of rumors and comments about how challenging attacks like this would affect Pittman-Robertson dollars. Now I'm getting questions and hearing comments about whether or not the plaintiffs here are delaying this litigation so as to delay any effects on Pittman-Robertson dollars. Can you speak to that at all?
Yeah, absolutely. I can tell you Pittman-Robertson has not come into the equation at all. And again, because there are different layers procedurally that we've had to consider and different strategies that we've attempted, there's really been no room to consider the effect on Pittman-Robertson dollars. The only delay that we intentionally did here was delaying on moving forward so that we could get time for the tax to actually be paid so that our dealers would have standing. So like unlike the Altbaum case where no tax had even been paid, we wouldn't get drummed out on the fact that there hadn't actually been a payment of the assessment. But there hasn't. Here's how I analogize tax challenges versus other challenges to laws and civil rights challenges in general. They talk about checkers versus chess. Well, this is sort of checkers versus that chess that Spock and Kirk used to play on the original Star Trek with the multiple levels. That is how different and nuanced tax challenges are. And so there's just no place in there for a piece that deals with Pittman-Robertson, at least not on a level that's going to greatly affect the timing or the strategy that we employ in trying to challenge the tax. I will be blunt. This is a very difficult challenge because, again, I think this was well thought out by the folks who finally passed wrote and passed AB 28. Because if it had been a 50% tax, then maybe going in and making that poll tax type argument I was talking about before would have more of a chance of success. Because a 50% tax, but an 11% tax is, it's kind of right on that line there. And they're trying to justify it as a public safety measure. 11% tax, I don't agree with it, but you get in front of the right judge, they can certainly agree with it. And so this was well thought out by the state, and we're attempting to match them move for move. They got us on the exhaustion of administrative remedies move, so we'll go through that, and then we'll come back and once we exhaust those administrative remedies, the only thing that will have happened is the delay, which is very unfortunate, but it won't have put us in a more difficult legal position. We'll be in the same legal position, except the state won't have that argument to be able to make to a judge, to allow a judge to go, yeah, I'm not even going to get to the substantive issue of whether this law is defensible or constitutional. I'm knocking you out because you didn't exhaust administrative remedies. That will be gone. So that's good.
And it sounds like what you're saying is the challenge here has to be calculated, which it clearly is. It's well thought out, but in that calculation, Pittman-Robertson dollars was not part of that calculation. And it seems to me, if it were to be part of that calculation, it would have been considered as to whether or not the lawsuit is filed or not, because then you would just be balancing Pittman-Robertson dollars versus this additional 11% tax. But that's at least something to go on. So, that's not really a consideration here. And as far as I'm concerned, that short delay to make sure the FFLs had standing is pretty darn important, because if you don't have standing as a plaintiff, the lawsuit gets thrown out right away. Every other delay that we're seeing, like this one, exhausting the administrative remedies, is being delayed by the state. So thank you for providing some insight and an answer to that one. Another one that I've gotten is having to do with the way it was challenged. Why not a class action lawsuit? What I guess first of all, how would a class action lawsuit be filed for this? And then after that, why didn't we choose to go that way? And is there room to do it now?
Well, no, there isn't, and here's why. If you were going to be filing a class action, one, class actions take time. So to the extent that there's considerations about delay, and we're, there certainly are considerations about delay. Uh, Filing a lawsuit as a class action is going to add years to it because there's a class identification, class discovery, certification process. But two, um, our assessment, we're raising this argument. We're not waiving this argument, but our assessment is that individuals standing to challenge this excise tax. In other words, me and you, when we go into a shop like Turner's to buy a firearm and we get tagged with an additional 11%. The case law is pretty clear that because we're not actually paying that 11% ourselves to the CDTFA, it's the Turner's of the world that are doing it. We don't have standing. Now, again, there are certain exceptions where there are clear violations of constitutional rights. And again, they have to be very clear. I'm talking like the poll tax context. Um, and again, here we certainly allege there's a Second Amendment violation, but it's not as clear as we as a legislature want to disenfranchise African American voters. Um, in those instances, there can sometimes be challenges by the individuals who are affected, but in almost every other instance, a downstream person affected by a tax, so a consumer who buys from a retailer who pays a tax, a retailer who buys from a wholesaler who pays a tax, those people are considered to not have standing to challenge the law. So even if we were to bring a class action and bring every affected person in the state who's had to pay more for a firearm since July of last year, there wouldn't be standing. We would get drummed out of court on that. And again, we'd get drummed out of court, maybe not right away because we might have to go through the machinations of identifying the class before the court ultimately decides there's no standing for those class members to allege this type of injury.
Well, that's fair, and I guess that's something that somebody who's not constantly involved in the law is thinking about. So, and we see TV shows like Suits where they just slap a class action lawsuit down. So, those things obviously are easy to consider, but it sounds like when you put it in the context of specifically this challenging a tax law, it's not really effective. I guess any final thoughts on your part on this lawsuit, on any questions that have arisen? And as always, this doesn't always end up being the straightest answer, but time-wise, with the hurdles we've got in front of us, what does the timeline look like on this?
The timeline is going to be drawn out, and it's going to be primarily driven by the CDTFA's procedures for challenging and how long they take to respond, and they could and probably will intentionally delay it. And that's the really frustrating part. That's what we were hoping to avoid. We were hoping we might catch the state with its pants down and it would waive that argument and we could move forward to the substantive arguments in court. But we didn't get them to bite. And that's going to add time to this. And if there were a way to speed this up, we would certainly do it. We have the utmost respect for Cooper and Kirk. We hope they have it for our firm. But they've done a lot of these types of challenges. We've done these types of challenges. If there were a way we thought we could do it faster and effectively, we absolutely would. I'm a California resident. I buy firearms quite often. I don't want to pay the 11%. I listen to my friends when I go shoot trap or whatever. They talk about how frustrating it is to go in and have an additional 11% slapped on the price of a shotgun or something they buy. It's personal to me. It's personal to everybody working on the case, and we would like this to go much faster. Unfortunately, given this type of challenge, it's just the delays built into it are I don't want to say they're intentional, but they're inherent in a system that sort of automatically defaults to the sovereign, in this case, the state of California and their CDTFA, sort of has the right to set the rules with regard to setting taxes and challenging those taxes. And that's the system we have to play in right now, because we can't run the federal court like we normally can with these sorts of Second Amendment issues.
Well, it's something we're certainly going to be following along with every step of the way. Josh, I want to thank you so much for bringing all the insight to this case that you brought today, and thanks for coming on with us.
Pleasure. It's always great to talk to you, Kevin. And keep up the good work, CRPA.
Yes, and you as well. Thanks again. I appreciate it. And guys, if you like content like this and you want to see more, you want to continue to be educated on the litigative and legislative efforts going on in California, please be sure to like, share, and subscribe to these videos. It's a way that you can directly contribute to those efforts in California so that we can keep the ball rolling in favor of the Second Amendment movement here in California. Thanks again, guys, and we'll see you on the next one.